Good morning, friends. The Madras High Court on 8/5/2020, while disposing the criminal miscellaneous petition number 5921 by 2020, held that the indefeasible right or the default right to get bail under section 167 clause 2 CRPC is not affected by the Supreme Court ruling extending the period of limitation. You may be knowing that the Honorable Supreme Court of India on March and extended on May also, the Honorable Court extended the limitation period for filing any petitions. To cite an example, I want to tell you, suppose A has given money to B under a pronote. You may be knowing the limitation period is 3 years. Suppose if the limitation period of 3 years is getting expired within this COVID-19 period, you need not worry. You can file the case when the court reopens. That is the use of the extension of a limitation. The second advantage is the Honorable Court, High Court or Supreme Court or some other courts, they might have given some stay orders or extension periods. So they can also be extended till the normalcy is resumed or till we relieve of the so-called COVID-19. But this is a statutory rule. It's according to section 167 clause 2 CRPC. So the Honorable Madras High Court Judge Mr. G.R. Swaminathan, he held that it is a statutory right and it is a right under right to life and liberty, Article 21 of the Constitution, to get the default bail. It is an indefeasible right. Therefore, I am not obliged by the so-called interpretation of the extension of the limitation period as per the Honorable Supreme Court of India guidelines. Therefore, he ordered the accused to be released on bail. Now, let's go into the crux or the details of the case. The case is like this. This case you can refer it as Sethu versus SETTU, Sethu versus State of Tamil Nadu. So, the accused Sethu, he was an accused in a robbery case. He was arrested. The case was registered under section 392 IPC as well as 397 IPC in a police station in Tamil Nadu state. So the police reacted quickly. So you may be knowing they have got umpteen powers according to section 47 or 41 or 47. So many sections are there. They are enough. They have got powers to arrest a person concerned in a cognizable offense, even on mere suspicion. They arrested him. You may be knowing, according to section 57 CRPC, if the investigation is not completed within 24 hours and if the accused cannot be released on bail within 24 hours, he has to be produced before the local magistrate. That is what section 20 says. Article 22 says he cannot be detained for more than 24 hours. Here you have to remember Article 21 also. Article 21 in brief it says no person shall be deprived of his life and personal liberty except as per the procedure established by law. Here please remember his liberty should not be curtailed. Of course, since he is except as per the procedure established by law, as per the due procedure, they have arrested him, he has to be in jail. Now, let us know what is section 392 say. 392 gives punishment to two types of offences. That is robbery, simply to say robbery. If 4 or less than that number of persons, so put a person under fear and commit theft, it is robbery. And according to section 392, there are two types of robberies. Number 1 is general robbery and the second is highway robbery. So the highway robbery, any highway between sunrise and sunset, if it is between sunset and sunrise if it is committed, then it's a dangerous thing. The punishment may be up to 14 years. For others it is 10 years. Right, okay. since it is triable by only magistrate, then he was arrested on 19/1/2020. He was arrested on 19th January 2020. Right? If it is an ordinary robbery case, the charge sheet has to be filed according to 167. So when he is produced by the magistrate according to 167, he will give a remand for a period of 15 like that normally will be given. But please remember, if the period of 60 days is completed and if the charge sheet is not filed in ordinary robbery cases, definitely he has to be released on bail. Of course, if it is more than 7 years, then the time limitation will be 90 days. So please remember, with 19/1 by 19/3, the 16 days period is over, 60 days period is over, and 18/4, the 90 days period is also over. But still, the police did not file the charge sheet. Now, his advocate, Mr. Karunakaran, has come up with a plea that it is a indefeasible right, or it is a definitely he has got a right to get bail because default bail is there according to 167 clause to CRPC. He has argued. Now, the plea put forth by the police, on behalf of the police, Mr. Robinson is the public prosecutor. He argued. He has cited the Supreme Court order. Supreme Court order stated that the period of limitation will be extended till the opening of the courts or till further orders, it has been stated. Now he has interpreted this called Supreme Court order. Mr. Justice Swaminathan, he has interpreted the Supreme Court order. So the noble intention, the intent behind giving the so-called order is for what? To see that every person is not deprived of his right to file a case within the period of limitation. Suppose if because of the COVID-19 period, because of the lockdown, the people may not be able to come to the court and file the cases. That too, courts are also being shut down. Therefore, they have raised the period of limitation. The intention is to see that the people are not deprived. That means the right of the common man is protected. This is also a right to fair trial. This is also under Article 21 of the Constitution of India. But here, please remember, this is so. Here once again he has discussed about the definition part also. Section 2J of the Limitation Act discusses what is limitation, the period of limitation. The period of limitation normally applies to suit, appeal and application. For these persons only the limitation applies, and that too according to section 6(5) of the Limitation Act, if you are able to give sufficient cause, it can be extended also. Like that we take the so-called extensions for years together. Days over, now years together also. In Odisha case, the Supreme Court itself guaranteed 368 days time or so limitation. It has condoned the delay. It is a different part. Now let us come back to our topic. Now he has emphasized on section 167 clause 2 of the CRPC. So it is a statute right. It is moreover, it is a constitutional right. So if the police do not file the final report under section 173 within the statutory period of 60 days or 90 days, whatever it is, then the accused has got a right to get bail provided he is able to furnish the sufficient sureties. Here he is ready with the sureties. Now, what to do? The Honorable High Court of Madras, Justice Swaminathan, he has stated that if I take into consideration the orders given by the Supreme Court, then the interpretation itself will go against to the rule of law. It is statutory. In the statute itself, CRPC itself, it is stated that it is an indefatigable right. That too, Justice V.R. Krishna here always says bail is a matter of right, jail is an option. And taking into consideration all these things, and he has, of course, he has stated so many things in other also. And even, for example, for the limitation, even according to section 468 of the CRPC, he said limitation is for filing of the charge sheet 6 months. If the offence is punishable only with a fine, 6 months period of limitation. If it is 1 year, 1 year, 3 years, 3 years, more than 3 years, no limitation. So The period of limitation does not apply to police cases. Therefore, he has ultimately released the accused to be ordered on bail after furnishing two sureties for an amount of 10,000, and he has given a direction that the accused has to attend before the police as and when required. And of course, in the just like he has stated in another case also, he can be rearrested provided there is enough material, or if the section is altered, if some other cases are pending. Basing on the case law of Rakesh Kumar Paul versus State of Assam 2017 does not mean that he should be released on bail, he should be kept on bail. If there is something material, extra material is coming, he can be arrested. And he relied another case also, Achpal versus State of Rajasthan. This is a period of limitation, 60 days or 90 days. So please remember, of course, this is the interpretation. We don't know. Tomorrow Supreme Court may say, when we extended the limitation, it extends to all, not even police. Are they not clients? They are also clients as far as the state is concerned. Supreme Court may also tell that thing, but as far as up to now, the Madras High Court rejected the so-called order and interpreted. I cannot say rejected. It has interpreted the order in this way and rejected the plea of the police and ultimately given bail to the accused. So please learn how things can be interpreted, how the judge's mind will react. This is more important in this case. Thank you.